Hi, everyone, and thank you for joining us at the Legal HR Summit. The Legal HR Summit is a two-day online event hosted by US Labores, the largest employment law alliance in the world. This session is part of the Americas bloc and will be followed another curated session of the region. I'm now turning over to Sonja Regenbogen to begin the session. Go ahead, Sonja, you can start.
Good afternoon. Thanks so much for joining us. We have some very interesting topics to discuss today, so we are very happy that you're able to tune in or that you might be watching this later on. So thank you so much for joining. This session is designed to talk about the legal risks that can cause reputational risks and the reputational risks that can cause legal risks in the current situation that we find ourselves in with respect to COVID, the pandemic, and its impact on workplaces throughout the Americas. My name is Sonja Regenbogen. I'm a partner at Matthews Dinsdale in Canada. And so I'll be speaking to you from the Canadian perspective, and I'm joined by my colleague from the United States. So we'll be giving you the view from both US and Canada throughout our presentation today. We would welcome if you have questions. If you're joining us live, please feel free to send us questions and we'll do our very best to answer them. So today we're going to cover three broad topics. We're going to talk about where some of the legal risks lie in respect of employees returning to work, employees on layoff, and employees returning to work in a remote capacity, for example. So we're going to deal with these three broad topics and discuss them between us. The first I want to kickstart off is under Canadian law, there are some important concepts to keep in mind when we're thinking about how to navigate to avoid the legal risks that may flow from handling our employees during the time of COVID and the restrictions that exist. One of the primary considerations that employers in Canada are thinking about is the Human Rights Code and the protected grounds that exist under the Human Rights Code around first, disability discrimination, which can include differential treatment on the basis of a medical condition. Also important to note that in Ontario in particular, but across a number of Canadian jurisdictions, there is also a protected ground around perceived disability, which could include perceptions around a medical condition. So both medical conditions or perceived medical conditions, if there's differential treatment on the basis of either of those protected grounds in the workplace, this could constitute discrimination contrary to our Human Rights Code. Medical conditions or perceived medical conditions, which of course would encompass COVID, must be accommodated up to the point of undue hardship, based on both cost and or health and safety considerations. And so important at the outset to know that COVID could be found, the COVID health and safety restrictions could be found to constitute undue hardship depending on the circumstances. So very important to, at the outset, be aware that this could trigger your obligations as an employer under the Human Rights Code to take into account the duty to accommodate for either medical condition of COVID or a perception around someone suffering from COVID or a family member suffering from COVID. Also, just at the outset, I want to point out that another important protected ground under the Human Rights Code in Ontario, for example, is that of family status. And so according to the Ontario Human Rights Commission, caregiving responsibilities that are related to COVID must also be accommodated up to the point of undue hardship. And so employers should ensure that any restrictions on an employee's participation in the workplace are consistent with the recent advice provided by medical and public health officials and are justified for health and safety reasons. Now, just very quickly, some best practices around, so I've talked about the duty to accommodate that's triggered under our human rights legislation if protected grounds are being considered, and some best practices around the process of ensuring that you've satisfied your legal obligations under the Human Rights Code is number one, to make the appropriate inquiries about the needs of an individual employee in good faith. Second is to request medical if necessary to support a better understanding of the individual's circumstances. And possibly a best practice could include covering the cost of that required medical information, ensuring a clear understanding of the employee's needs and requests in respect of their participation in the workplace, exploring the various options that may exist in order to have a cooperative approach to finding a solution if the employee is able to continue to contribute in the workplace. It is important at this stage that I highlight that in our view, it is not discriminatory in contravention of Canadian human rights legislation to lay off employees if there is no work for them because of the impact of COVID. And I'll just very briefly talk about the fact that in Ontario, specific legislative measures have been introduced in order to try to take into account the medical leave that may be necessary for employees because they're either required to isolate or quarantine due to COVID or COVID exposure, and also employees who are experiencing COVID, but also employees who are in caregiving responsibilities because of COVID. So the Ontario government has changed a number of rules under our employment standards legislation, and this period of the new COVID leave has been extended to, at this time, January the 2nd of 2021. And so this applies to non-unionized employees who have either had their work temporarily reduced or hours eliminated. It allows the employer to treat those individuals as on a COVID leave, which is a job protected leave under the Employment Standards Act. And the other important point of this legislative change to the Employment Standards Act is that now, and again, this only applies to non-unionized employees, but non-unionized employees who are temporarily laid off or required to be on a leave as a result of one of the reasons that I identified are not considered to have been dismissed by the employer. So not constructively dismissed or actually dismissed. What this also means in terms of keeping in mind important dates to insert in your calendars, because this leave has been extended until January the 2nd, for the practical purposes at this time, again, subject to a further extension, for a practical purpose, an employee's temporary layoff clock resets on January the 3rd, 2021. So just to recap, a couple of important concepts is that how you manage your employees, either remotely or returning to work, or if you've continued operations, you do need to be alive to the Human Rights Code duty to accommodate where there is an individual suffering from COVID or may have caregiving responsibilities because of COVID, number one. And number two, very important to be aware of the various legislative leaves that exist that allow an employee either suffering from COVID or isolating or quarantining or providing caregiving responsibilities, that COVID leave is something that is triggered now in Ontario. So with that, Jeff, I'll turn it over to you for some American perspective.
Thanks, Sonia. Hi, everyone. I'm Jeff Douglas. I'm a partner at Ford Harrison, based in New York and New Jersey. Listening to Sonia's presentation of Canadian law, there are a few things that are really striking in comparison to U.S. law. Number one, it seems much more organized in Canada than it does in the U.S. Because from, I think, our perspective, we're seeing really like a hodgepodge of different laws, regulations, or rules that are impacting how employers are dealing with COVID and COVID employment issues. So before I jump into that, just a quick distinction between the US and probably most other jurisdictions really deals with the nature of the employment relationship at the outset. Most employees in the US are something called at will. Really, employees have very few protections. An employer can terminate an employee for a good reason, a bad reason, a made-up reason, no reason. It just can't be an unlawful reason. And so that's where a lot of the legislation that we're going to talk about now comes into play. One other thing that's important, I think similar to Canadian law, but maybe even more so, is that we have different levels of law here. We have federal law, which applies throughout the US, then we have state law, and then we have local law. Certainly where I am based in New York City, we have at least 3 levels of law here, all trying to interact with each other, and sometimes not so smoothly. And so just to give a quick 30,000-foot perspective of what employers need to be considering when they're dealing with COVID-related issues, I'll kind of jump into that. But before I do that, one thing that I think a lot of employers are losing sight of is that COVID in many ways fits into the traditional way that we have to view, for example, disability discrimination, and having that interactive process with our employees. So just to kind of highlight some of the federal legislation and guidance at play, and then maybe we talk a little bit about some of the state issues at play. The big legislation we're dealing with is the FFCRA, which is the congressional act that was passed, and it's created some new protected statuses specifically related to COVID. If someone's sick, if someone has to quarantine, brand new protections for essentially caregiving status for child care. We're one of very few countries, I think, that doesn't really have maternity leave, paternity leave, except at the state level. So this is all very new for many, many jurisdictions within the US. So we have this legislation, but then we also have a lot of guidance from the Centers for Disease Control, the Department of Labor, the Equal Employment Opportunity Commission, OSHA. And then, of course, the states come in and say, well, we're going to do it differently. And you have to figure out, employer, how these things interact with each other. And so I think it's been very difficult for employers to try to parse through a lot of these things. And so at the outset, I think it's really important for employers to remember not to get lost in the weeds. And as Sonia had mentioned, in Canadian law, we have disparate treatment, which I think is very similar conceptually to the Canadian equivalent, but then also that interactive process. And I think for employers, one of the things that's most important is making sure that the higher ups, managers, et cetera, are all empowered to know how to deal with those issues as they arise. One of the things we're seeing a lot of is, being put on notice. Someone came in contact with someone who is COVID positive, and then really escalating that, following the policies and procedures in place to ensure that we engage in that interactive process, so that way employers are dealing with these issues effectively. In the US, for example, we have very strong anti-disability discrimination laws, really protecting people with disabilities. We're very limited on a general basis as to what kind of information an employer can ask for in that interactive process. Can an employer proactively ask, do you have a fever? Do you have a pre-existing condition? And what we're seeing is, for really one of the first times I can recall, the Federal Equal Employment Opportunity Commission saying, this is an exception. COVID is an exception to what we typically deal with. And so you can go ahead and ask certain questions, ask for certain information that you normally would not be able to ask, because it may trigger an employee having to reveal something about a disability that they didn't want to reveal. But it shows that there's a real balance going on here between the protections that exist for disability, but also protecting a workforce in general. And one of the things that I wanted to raise here is, we have this normal framework that we're operating in, but we're also supposed to talk a little bit about managerial risk and reputation and all that kind of stuff. And I think that this may lead us into some further discussion, but I think there are real opportunities here for employers, both proactive opportunities, but also in the US at least, where we are very litigious, liability perspective and risk aversion, to educate, empower managers, the people who are really your front line dealing with rank and file employees, about how to have those conversations with employees, but also knowing when to escalate it to HR, to in-house counsel, so that way we can make sure that policies and decision making is being conducted uniformly. Because I'm already starting to see litigation resulting from COVID. And I think one of the issues that we're seeing is policies not being implemented uniformly across the board. And the very reality is, in a country like the US, where we do have very few employee protections, at least monetary protections, um, the only recourse for a lot of employees who have been laid off or desperate for money is litigation. And so, from the employer perspective, we really want to try to prevent that as much as possible by making sure that we're doing everything we can within the framework that exists. I was on a client call this morning. They threw me a hypothetical about how federal law and New York law interact with each other. And the truth of the matter is, a lot of this stuff was passed very quickly. And there are some contradictions. And I think it's really important that companies view those contradictions, recognize them, and when necessary, consult in-house counsel, outside counsel, to try to deal with those issues because they are complicated. And I think we're going to see a lot of litigation as a result of that. One other thing to raise, because I think one of the few areas in the US where there are some additional protections for employees where they're not necessarily at will, is in the unionized context. And in the unionized context where employees are not will, there may be a just cause provision that gives them a little more security. One of the things that we've been seeing a little bit of, and I have a client that had this, was how to deal with work stoppages as a result of this. Um, it happens from time to time in the US. Oftentimes, when there's a collective bargaining agreement, it'll contain a no strikes provision where employees really can't engage in work stoppages. But for example, I had a client where they called me up one morning and they said, our drivers don't want to drive because we're telling them they need to distribute food into supermarkets and they don't want to go into the supermarkets. Now, the first line of defense there was the manager. He had no idea what to do because this is so unusual. And so making sure that managers are educated as to, well, how do I deal with a situation like that? Knowing that there may be certain exceptions to a no strikes clause for health and safety issues, but that the workers have to demonstrate very, very specific things in order to overcome a no strikes provision. So it's really important that employers are very familiar with the content of their collective bargaining agreements. But also employers who are non-unionized have to remember they're still subject to certain legislation like the National Labor Relations Act that allows employees to engage in concerted activity. So there's really a lot going on in the US, both at the federal level and the state level, that I think employers, and when I use the word employer, I mean upper management, but also that frontline management really need to be educated about because these things are happening very quickly. The law is changing very quickly. For example, in New Jersey, there was an executive order that was issued last week that's changed things completely. There are a new executive order in New York dealing with travel restrictions. So employers really need to stay up on this and be educating their management about these changes and how to deal with their employees as it relates to that. So kind of switching gears a little bit and delving into some return to work issues. I'm going to start with the US side of things and then throw it back to Sonia for the Canadian part of this. One thing I really want to focus on from a remote work issue in the US in particular is wage and hour law. Wage and hour law, I think, exists elsewhere, but is not as controversial or litigious an issue as it is in the US. In the US, a lot of employment litigation does involve wage and hour law, essentially unpaid overtime, minimum wage violations, and a lot of the penalties that come along with that. It is an incredibly expensive area of litigation for employers. The damages are astronomical. They could be at least 200%, plus attorney's fees and penalties. And it's really not something that employers want to find themselves in. not only, dealing with individual employees, but I think one of the big things in the US is we deal with a lot of class and collective action wage and hour cases where, it's not just one employee you're dealing with, but it's potential for all similarly situated employees. Um, and that gives plaintiffs' attorneys a large incentive to pursue these actions. And I think we're going to see a lot more of that as it relates to return to work. Um, Kind of highlighting an issue for our non-US audience. In my experience, at least dealing with and counseling some non-US employers, I've experienced at least some pushback on having proper timekeeping policies, classifying employees as non-exempt, because I think the notion of punching a clock, they feel it impacts culture. But if there's anything I can stress to our non-US audience today is wage and hour compliance is everything. Wage and hour litigation can be make it or break it litigation for an employer. And so I can't emphasize enough just how important wage and hour compliance is. And I think this is going to be really important, especially with employees working from home. We have no idea what they're doing at home. We like to think we do. It's very easy for a non-exempt hourly overtime eligible employee to, be working 15 hours a day because they sign on here, they respond to an email, they go do something else, they come back and respond to an email. And by the time it's all said and done, they've been working for 60 hours. That's 20 hours of overtime, quite expensive. Um, so, a few things that to advise on this, especially with employees working from home. Number one, there's a great opportunity to make sure all employees are classified properly. A lot of newer companies sometimes have the false impression that everyone's exempt, everyone gets a salary, and it's wonderful. But we have no way of knowing how many hours people are working, and chances are they're not all salaried. So number one, wage and hour audit. Make sure your employees are classified properly. Number two, make sure you have a good timekeeping system. You don't have to have employees feel like they're punching the clock. There are other ways to do it. But in wage and hour litigation in the US, an employee can assert in a complaint that they're working 100 hours a week. The burden shifts to the employer to come back with time records. If there are no time records, the burden's with the employer throughout the duration of litigation. And it's really hard to prove a negative. It's really hard to prove that they didn't work the hours that they're alleging. The third thing is enforcement procedures. And I think this is where managers come in to be really important players. Managers know what their subordinates are doing throughout the day because they're the ones who are in communication. They're the ones who should be controlling the hours that they're working. We want to prevent off the clock work, the notion that, hourly employees are responding to emails at midnight because the company could be responsible for paying them. We want to make sure managers know how to field overtime requests. We want to make sure managers know how to escalate these things to HR and that they're reviewing time records on a weekly basis to make sure they're accurate. The fourth step is knowing how to discipline. No one likes to have to discipline, especially for wage and hour issues. But unfortunately, that's the only, I shouldn't say the only, but it's the primary way of making sure that employees are following the rules properly so you can avoid significant liability. I guess with that, Sonia, I'll turn it back to you. We'll go from there.
Sounds good. Thank you, Jeff. So I think that this is also an important issue, wage and hour and overtime, to talk about from the Canadian perspective. So often we'll have clients who operate both in Canada and the US. And I sort of joke that Canadian plaintiff lawyers have gone to school at the feet of the American lawyers who have pioneered the very significant and serious wage and hour compliance litigation that happens in the US. And while we haven't seen the same volume or the same damages that arise from the claims, we have seen, particularly in the financial services industry, class actions being certified where a category of employees have been designated as not entitled to overtime. So we have slightly different language in Canada than the US concepts of exempt or not exempt, but the same idea. Then a category or classification of employee is either entitled to overtime or they're not entitled to overtime. And in Canada, especially a lot of American employers that also operate in Canada assume it's the same sort of threshold, and it's not always the case. And so in Canada, there's a much more restrictive idea of who is excluded from entitlement to overtime. And so you may have employees who are paid in a salaried fashion, and a lot of multinationals or American companies will assume that that's sufficient to categorize that individual or that group of individuals as not entitled to overtime in Canada, and that's actually not the case. So you can have salaried employees who are working in a professional context that may still be entitled to overtime in Canada. So very important for employers to have in Canada also to think about an audit to make sure that the employees that are considered not entitled to overtime are in fact truly not entitled to overtime, and to ensure that if there are employees working that are entitled to overtime and they are working that overtime, that they are paid in compliance with the legal obligations to do so. So very important to also survey your own internal status in respect of those employees. And I think, as we've seen, certainly in Ontario and throughout other provinces in Canada, the initial reaction to the COVID pandemic was to require most businesses to close their physical operations, with certain exceptions for essential businesses that were designated. So, of course, some employers have continued in the physical workspaces or facilities throughout the entire pandemic, but some employers, according to those government orders, were required to close their physical premises and therefore move their employees to remote work if that was possible, to continue the business in that way. And so I think Jeff also raises a really important point that is part of the challenge of having a remote workforce almost overnight is that a lot of employers don't have either remote working policies, but also haven't connected that to the issue of hours of work and our overtime pay compliance. So definitely also important from a Canadian perspective to make sure first that you've classified employees correctly as being either entitled to overtime or not. And number two, that there is some kind of a timekeeping system for employees who are working remotely. It will not be a sufficient defense for an employer. I like when Jeff said, it's difficult to prove a negative. And
I've tried many times.
Right? Exactly. So, at the end of the day, it's the employer's obligation at law to make sure that employees are not working overtime that they're not being compensated for. Or in Ontario, there are caps on hours of work. So there are sort of absolute limits on hours of work. So there is also a timekeeping work management responsibility on the employer in Canada to make sure that employees are not exceeding the permissible hours of work that exist in a week, for example. So definitely some kind of a timekeeping system. And, this is something that probably a lot of employers haven't actually turned their minds to. So I think that this is an important point. And to Jeff's point also, in Canada, I think it's also an important aspect to train your supervisors or managers on what is the timekeeping policy or timekeeping system that exists. What is the hours of work policy that applies to those employees, and to make sure that your frontline managers are in fact enforcing these hours of work provisions. It is not sufficient to say, and I know this issue comes up a lot when there is an hours of work policy, to say, well, listen, we have a policy that requires advance approval of overtime, and that person didn't get advance approval, and so the claim for overtime should be defeated on that basis. That will not be an argument that wins the day. And so it is not sufficient for an employer to say that someone needed approval in advance. And also, to Jeff's point about discipline, this is something that if you have an employee who is working excess hours and or overtime hours that they have not sought advance approval for, that is an employment offense for which they can be disciplined. And that's probably the right way to go. And obviously, some decision about the severity of the discipline should be discussed. But that is a situation in which the employer can take the position that you've not followed the policy, and so discipline is appropriate, but the overtime still has to be paid. And so important to have those enforcement procedures internally. And I do think, it is more complicated. I'm sure we've all found that when we're working from home, we're in an environment where we end up probably working more than we may if we physically leave our workspace or our office. And so I think this is all the more important now to make sure, first and foremost, that you have a remote work from home policy, and also that you have an hours of work policy and some kind of a timekeeping system as well. Some other issues in terms of best practices in managing your employees who are now working remotely is setting milestones for check-in. This is also important so that people are accountable for projects and deliverables, but that there's also an expectation that there's going to be an ongoing and continued level of communication between supervisors or managers and their staff. And of course, supervisors, managers, and upper management or leadership. So setting regular check-ins, regular milestones, regular meetings with expectations or status updates is definitely important. That also feeds in to the requirement that we would suggest is sort of a top priority, which is maintaining strong communication. So creating some kind of a platform over which communication can exist, and that it's regular communication. So whether it's something like the Zoom technology that we're using today, or Microsoft Teams, or there's all sorts of video platforms now so that people can stay in contact, or other kinds of text or email communication systems. Also, definitely an issue that we're seeing a lot of questions around is dealing with trying to providing a support system to employees to support strong mental health and good employee morale. And definitely that a part of that is communicating, feeling like you're still part of something, you're still connected to your larger team, the larger goals of the organization, but also setting boundaries. And this connects also with the potential wage and hour litigation risk, which we've both described to you in terms of what the legal risks are. But I think from the employee morale perspective, it's also a good idea to set clear boundaries and expectations about hours of work and availability. Also maintaining some flexibility, recognizing that working from home is going to have some additional challenges or some additional barriers for some folks who have either childcare obligations, perhaps homeschooling requirements, pets. I don't know, you runs the gamut of things that can keep people busy and otherwise engaged. But setting those boundaries and expectations around working time and availability is important. Also creating a process for both employee feedback, so that's the feedback from the supervisor or manager to the employee, but also sort of the 360 idea. How can you benefit from feedback from your employees on how to communicate better, how to manage projects more efficiently in the current time? Definitely opportunities for learning in that respect. And that feeds into sort of the last best practice that I would suggest, which is trying to make a significant effort to keep employees engaged in the work, but also in their team and the goals of the organization. So positive feedback, celebrating success, virtual events to stay connected. I know a lot of law firms and some of our clients are doing sort of lunch and learns happening over Zoom or video, or even just sort of informal grab a coffee and chat about what's going on over the Zoom or other video platform to keep people connected